Now, Carol, in the last segment, we were talking about what the court found that that the disciplinary procedure that had expelled Mr. Zaki lacked procedural fairness, in part because of a reasonable apprehension of bias by one of the decision makers. But another thing you argued was related to the question of whether the school actually even had jurisdiction to punish this student for personal Facebook posts. What did the court decide on that issue?
The court did not side with us on that issue. There's a procedure under which Mr. Zaki was disciplined. And under that procedure, it says that the university has the right to regulate social media if the social media is regarding the university or its members. Our argument was Mr. Zaki's post was not about the university or its members. It was about a Sunday school post that he had for his church. And so, but the court differed with us on that because the court found there was enough evidence that the social media was directed to individuals at the university.
I mean, it seems like a pretty broad interpretation to me. Can you, Carol, imagine a scenario where social media posts may not fall under the jurisdiction of the school? I mean, he has friends from the school on his Facebook. But for example, if instead he had titled it, here is a lecture I prepared for my Sunday school, do you think maybe the decision would have been different? Because I'm not convinced his classmates wouldn't have complained about that too, even if it's clearly not directed at them.
We argued that, Christine. We find it difficult to think of a situation where a student wouldn't intend their social media to also go to their classmates. Yes, and that was our problem with jurisdiction.
Yeah, interesting holding there. But for me, what the most interesting part of this case is the charter argument. Because it really is unsettled law about whether the charter applies or doesn't apply to a university disciplinary decision. And there's been conflicting case law from across Canada on this issue. So what did the court find in your case?
Well, I'm happy to report that the court, from this moment forward, the court's decision means that the charter applies to student discipline on the campuses, post-secondary campuses in Manitoba. And of course, that's landmark. You're right. There's conflicting jurisdiction across Canada. And as a constitutional lawyer, that's a matter of concern for me. And so we're very happy to see that. The court found that under an Administrative Education Act that's over the university in Manitoba. So we're thrilled to see that this point forward, students like Mr. Zaki, if they share something that bothers someone, the charter will protect them and the university will have to consider the charter. The university did not do that here.
Yeah, and of course, for our viewers, the charter is what guarantees your right to freedom of expression, freedom of religion. And so this is a really big decision. Will be interesting to see how it is applied in future scenarios. Carol, what do you think it will mean for non-academic student discipline on campuses in the future?
Oh, Christine, if I could count the times that students have said to me, but I don't have a right to free speech on my campus. People are stunned by that because universities are supposed to be bastions of free speech, but yet there's no protection. It should be the place where speech flourishes. And so this will push that forward for all students, not just for Mr. Zaki. Students, no matter what they believe, will now have that protection on campus.
Yeah, I know, Carol, you've mentioned these other students, and I know you have worked with other students. For example, I'm familiar with one of your cases in Ontario related to a Ryerson student who was let go from his role with the student newspaper for his views on abortion. Do you think that this decision, it's coming out of Manitoba, but do you think it will have bearing on that Ontario case?
You know, I don't think technically it will, Christine, because you're speaking of Jonathan Bradley. He was terminated from the Eye Opener, a student newspaper on the campus at Ryerson, and that is before the Human Rights Tribunal of Ontario right now. Technically, the Eye Opener is a private corporation, and so the charter does not apply in the same way, but the principles do. And I think the principles behind the Zaki case will help Mr. Bradley, because it's a recognition that free speech should be cemented on these campuses. If that's what a university is for, so they can go to school and learn varying perspectives, surely Mr. Bradley, as a journalist, should be able to have his perspectives privately.